joining us this morning. Today's Senate Gaming Committee will be to take action on the Governor's Executive Order number 2025-02, which was signed and issued on May 30th, 2025. For those who are not aware of or familiar with the Governor's EO, it's basically to transfer authority for supervision of casino gaming from the Casino Commission to the Lottery Commission. At this time, I would like to inform the public that this committee meeting is being streamed live on the legislature's Facebook page and YouTube channel. I would also like to ask everyone before we begin to please silence your electronic devices to minimize any disruptions. I am Senator Karina L. McGovern from the 3rd Senatorial District, chairperson of the Senate Standing Committee on Gaming. I now call this meeting to order. Today is July 7, 2025, Monday. It is approximately 10:20 a.m. here at the Commonwealth Legislature, Capitol Hill, Saipan. Ellen Macronis, please call the roll.
Senator Ronnie M. Calvo,
Present.
Senator Francisco Q. Cruz, Senator Jude U. Hofschneider, Senator Carl R. King Neighbors,
Here.
Senator Karina L. Magofian,
Present.
Senator Donald M. Manglonia.
Present.
Madam Chair, there are 4 members present and 2 members absent.
Thank you, Devin. With 4 members present, we meet the necessary quorum to conduct today's meeting. Let the record reflect the Senators Hofschneider and Cruz are hereby excused from today's committee meeting. I'd also like to recognize our Legislative Bureau support staff who are assisting us this morning. We have our legal counsel, Antoinette Villagomez, our legislative assistant, Devin Macaranes, Sergeant at Arms, Ben Terlahi, and our IT, Delbert Camacho. Can I please get a motion to adopt today's agenda?
Motion to adopt today's agenda.
Thank you. A motion was offered and seconded. All those in favor say aye. Those opposed say nay. Motion carries. The agenda for today's meeting is hereby adopted. Thank you, members. Next item on the agenda is public comment. The floor is now open for public comments. If anyone in the gallery wishes to provide comments relevant to today's agenda, please join us in the chamber. Okay. 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 It appears that we have no comment from the public at this time. So the public comment portion of the agenda is now closed. I'd just like to recognize the attendance of the casino commissioners who are here today with us. We have Chairman Ed De Leon Guerrero, Commissioner Mario Taitano, and Commissioner Ralph Dimapan. Thank you. Okay. Next on our agenda is our new business. Under new business, we have one item, which is the Governor's Executive Order 2025-2. Again, this executive order was signed and issued on May 30th of this year. The Governor cited NMI Constitution Article 3, subsections 1 and 15, to substantiate the authority that allows him to issue the EO. Under this subsection 1, it states that the executive power of the Commonwealth shall be vested in a governor who shall be responsible for the faithful execution of the laws. And subsection 15 states that it permits the governor to make changes in the allocation of offices, agencies, and instrumentalities and in their functions and duties that are necessary for efficient administration. Based on these subsections cited by the governor, this is where the committee focused its time and review. And after a thorough review of these 2 subsections of the CNMI Constitution, the committee believes that the governor may have exceeded his authority under NMI Constitution Article 3, Section 15 by signing the executive order. At this time, I would like to ask our legal counsel to explain the legal background of the findings and provide examples of CNMI court cases to substantiate our claim. Counsel, please.
Thank you, Chair, and good morning to you and the members of the committee. Going back to the executive order, basically the executive order attempts to do several things. Number one, under Section 1 enactment, the executive order transfers the duties and responsibilities of the Commonwealth Commission to supervise casino gaming transfers the duties and responsibilities of the Casino Commission to supervise casino gaming in the Commonwealth to the Commonwealth Lottery Commission. Second, it says to the greatest extent possible under applicable law, the authority for enforcement of the existing casino license agreement between the Commonwealth and the exclusive licensee of the sole casino license, including authority to negotiate and cure amounts for encumbrances on said license, is likewise transferred to the Lottery Commission. Number three, it says because the Commission is divested by this order of any statutory duties or responsibilities, the Commission is no longer owed duties within the meaning of NMI Constitution Article 3, Section 21, and their terms are accordingly terminated. So these are basically the three things that this executive order is attempting to do. While the governor does have authority to reallocate offices under Article 3, Section 15, he does have limitations. He does not have, the governor cannot legislate by executive order. And the Supreme Court, in the case Torres v. Commonwealth, 2009 MP 14, provides guidance on the limits of the governor's authority to reallocate or reorganize executive branch departments and agencies. So in Torres, basically the court was reviewing two executive orders involving the Commonwealth Utilities Corporation. At that time, Governor Fitio attempted to transfer CUC, which was a public corporation, and transfer it to the Department of Public Works, which is a department under the executive branch. When he did that, he abolished the executive order abolished the existing CUC board members at that time, and then created or attempted to create like a chief executive officer to head CUC under the department as a division. So the legislature, while the legislature was reviewing that executive order, the governor issued several executive orders after that. And I think the fourth one was another executive order where he rescinded the first executive order transferring CUC to DPW. He rescinded that, put CUC back as a public corporation, but then also made some changes within the executive order. So those executive orders were challenged by two CUC customers, and it went all the way up to the Supreme Court. And then the Supreme Court said in that case that while the governor is given broad powers to reorganize the executive branch pursuant to NMI Constitution Article 3 and Section 15, it doesn't allow the governor to create a new entity, agency, or department. This constitutional power is vested solely in the legislature. The court also held that by attempting to reestablish CUC after it had been consolidated within DPW, the governor created a new executive branch entity, thereby usurping the authority of the legislative branch. Because the executive order establishing the new entity was constitutionally defective, the resulting increase in utility fees were also defective. Moreover, the governor in the case, the Supreme Court in the case said the governor further altered the nature of CUC's administration, in some cases completely nullifying existing statutory schemes when he abolished the board of directors. By radically altering the CUC enabling statutes in both executive orders, the governor essentially engaged in the legislative process. Since only the legislature may make substantial changes to existing law, both orders infringe on that authority. Similarly, Executive Order 2025-02 attempts to transfer the duties and responsibilities of the Casino Commission to the Lottery Commission. The executive order also terminates the casino commissioners with cause and attempts to expand the role of the Lottery Commission through an executive order. So basically, applying the court's holding in the Torres case to the current EO, it appears that the governor may have exceeded his authority for several reasons. First, the executive order alters the administrative framework of 4 CMC 2313 that created the Commonwealth Commission. Unlike the Lottery Commission, which is allocated to the Department of Finance, the Casino Commission is an autonomous public agency with its own fiscal and administrative powers. The Casino Commission will lose its autonomous status under the executive order. Unlike the Lottery Commission, with the Secretary of Finance, the Commerce Secretary, DPS Commissioner, and the Attorney General listed as the commissioners, the Casino Enabling Statute provides that there are 5 casino commissioners appointed by the governor and confirmed by the Senate, who represent the 1st, 2nd, and 3rd senatorial districts, serve 1 6-year terms, and the governor fills vacancies by appointment. The Lottery Commission doesn't have any of these provisions. Although 3 of the 4 lottery commissioners are appointed by the governor and confirmed by the Senate to the office that they hold, they were not appointed and confirmed in the same manner as the Commonwealth Commissioners. Unlike the Lottery Commission, the casino commissioners must be of good moral character. They must possess a bachelor's degree, have management experience, and are restricted from having direct or indirect interest in any casino license. These requirements do not apply to the lottery commissioners under the Lottery Commission. So basically, the executive order by attempts to remove or repeal these laws that are in place that are required for the casino commissioners. Secondly, the executive also contradicts or contravenes certain statutory provisions in 4 CMC 2313 establishing the Casino Commission. Unlike the Lottery Commission, the casino commissioners cannot be government employees. That's in the law. However, the lottery commissioners are all government employees. The Secretary of Finance, Secretary of Commerce, the DPS Commissioner, and the Attorney General. That's contrary to the Casino Commission statute. Another conflict is that the Attorney General is not even appointed. He's elected. The casino commissioners are required to be appointed and confirmed by the Senate. However, our Attorney General is elected. Another conflict is that the Attorney General represents the Casino Commission in all legal matters. And now the EO proposes to transfer this commission under the Lottery Commission, where the Attorney General is an official member by a statute of the commission. So you're going to have the Attorney General on the commission, the Lottery Commission, and then also representing the casino commissioners in litigation. I believe this might create a conflict too. There's other conflicts. Unlike the Lottery Commission, the casino commissioners cannot be removed from office without cause. Again, that is in the statute. The casino commissioners cannot be removed without cause. But what the executive order does is actually by transferring the duties and responsibilities of the commission to the Lottery Commission, the executive also states that it's terminating with cause the casino commissioners, which is contrary to, again, the casino gaming statute. And it's arguable that by transferring the duties from Casino Commission to Lottery Commission creates a with cause termination for the commissioners. So I think that's another conflict that's created by the executive order. Additionally, the executive order expands the role of the Lottery Commission and creates a new entity, transferring the Casino Commission to the Lottery Commission. Once transferred, the Casino Commission will be governed by the Lottery Commission, and the Lottery Commission's responsibilities are expanded, and their duties, which do not exist in the Lottery Commission's enabling statute, we're transferring them, the Casino Commission, to the Lottery Commission, giving the Lottery Commission additional responsibilities that are not in their statute right now. And that transfer also creates conflicts because under the Casino Commission, the day-to-day work or operations is is managed by the Secretary of Finance under the Casino Commission. For the Lottery Commission, we have an executive director. The law provides for the executive director to manage the the Casino Commission. So once transferred, it's unclear, it's ambiguous who's going to manage the operations of the commission. Is it going to be this executive director, or is it going to be the secretary? Again, it's not clear from the executive order, or the executive order creates an ambiguity in that area. So again, the executive does more than just transfer the casino commission to the lottery commission. It changes the administrative framework of the casino commissioners, how they're appointed, how they're selected. It also changes the number of commissioners. It changes. It doesn't even the law mandates that we have commissioners from Tinian and Rhoda. There's no requirement that the lottery commission have commissioners from Tinian and Rhoda. So again, the EO attempts to repeal existing casino commission laws or provisions of our casino commission laws. Again, that is, it's repealing these laws, which the governor doesn't have the authority to do. It's a legislative function. The legislature is the only body that can enact laws and repeal laws. And in this case, the executive order is attempting to repeal certain laws. So the repealing of certain laws, the changing of the framework of the lottery commission, the commissioners that are going to basically supervise casino gaming, and also this creating this new entity. The lottery commission will be who will absorb the casino commission, and I'm not sure what the casino commission is going to be under. Is it a new entity, or is it going to just fall under the lottery commission? It's unclear what's going to happen. And again, it's going to create conflict because the casino commission is supposed to be an autonomous public agency, separate from the direct supervision of the executive branch. That was the legislature's intent, to separate the casino commission and the executive branch. Although let me correct myself, the casino commission falls within the executive branch, but as a public autonomous agency, not a line agency. And the executive order, by transferring the casino commission to the lottery commission, basically puts it under a department and removes any autonomous, or attempts to remove any autonomous power that the casino commission might have today. So based on all these examples of how the executive order basically is legislating, it is my opinion that the executive order exceeds the governor's authority under Article 3, Section 15. I can take any questions, Chair, members.
Thank you very much, Council, for that explanation. At this time, I open the floor for the discussion. Recognize Senator Carl.
Thank you, Madam Chair. And this is to our legal counsel. As it relates to the firing or the removal of the Commonwealth Casino Commission with cause, am I wrong in that the Constitution itself enumerates the language necessary to remove a person with cause? Meaning the Constitution spells out the language that needs to be used for a cause to be effectuated for the removal.
Yes, the Constitution, Article 3, Section. Wait, I'm trying to find the section of the Constitution. Boards and commissions. Oh yes, Section 21. The Article 3, Section 1, or Section 21, boards and commissions. It says in every case where the governor appoints a board or commission to perform a regulatory administrative function or direct the activities of an agency, authority, or public or quasi-public corporation in the performance of a regulatory or administrative function. The members of such board or commission shall be independent and may be removed only on grounds of gross neglect, dereliction of duty, breach of fiduciary duty, conviction of a felony, or mental or physical capacity. So our Constitution is clear that these are the only grounds in which board or commission, and in this case, the Casino Commission is a regulatory agency. These are the only grounds in which the governor can remove these commissioners. So it appears again that the governor just by transferring the Casino Commission to the Lottery Commission is stating that that's the grounds for their termination with cause, but it's inconsistent with the language of our Constitution.
So I kind of want to, if I may, let's pivot away from, and thank you for that, legal counsel. That I really appreciate your input and also your thoroughness in your research to provide this body with the information that we need to kind of flesh through what we're endeavoring to complete, which is whether or not we're going to reject this executive order or proceed. I kind of want to shift gears into just the practicality of it all. The executive order identifies the need for this combination, or for the removal of the Casino Commission and to be absorbed by the Lottery Commission, basically because lack of funding, to streamline the process, to make it more convenient and able for them to move forward. What I, after listening to Council Villagomez and reviewing all the research, it seems like the executive order is causing more trouble, or possibly have more obstacles in place if we don't act on it and reject it than if we do allow it to go through. In our previous committee meeting, where we did ask the presence and the testimony of the members of the Casino Commission, the chairman, Commissioner Taitano was here as well. They articulated their inclination to bring forward a litigation because of the exact example that Council Villagomez had just referred to, that the language necessary to invoke cause for removal is absent in the executive order. Now we know that there's going to be a possible, or most likely, a litigation to proceed if the executive order is not rejected. Now, during our discussions, Council Villagomez noted that this case that she's citing from the Supreme Court was submitted in 2006, correct? And it wasn't finally adjudicated, and the ruling didn't come down until 2009. So now we're looking at that point in time, that was a 3-year turnaround. We have an investor now currently who was seeking to participate and look into investing in the very same, through the Casino Commission here on Saipan. And I worry that just as an investor, are they willing to stay for the next 3 years until this is flushed out? Furthermore, what about other investors in this particular field? This will throw our casino, this will throw the oversight of the Casino Commission and the regulatory body in flux and in a state of instability, in a moment of time where we need some continuity to finish out, whether it's the bankruptcy followings, proceedings, whatever it may be. I just don't think that this is the proper approach. Now, moving on to just the first component of what Council Villagomez mentioned was the legislature's stance and our role in this whole exercise is I knowing that there, or at least in my opinion, that this executive order is going to cause more problems than it looks to fix. Why should the legislature obfuscate or give away its legislative authority to make things more convoluted for this process? I guess I feel as if if we were being genuine and honest about the execution of what this executive order is attempting to remedy, then I felt, just my own opinion, that the proper due course would have been a letter to the Speaker of the House, the Senate President, the respective chairs of both committees of the House, so that we could identify the exact action items that maybe the executive branch or the governor felt needed to be addressed, and that in doing so, it would have allowed us, during, again, referring back to our meeting with the commissioners, they were open and offered their time at our earliest convenience to speak about what changes could be made, talk about what are the possible problems or benefits that these changes would look like. So I just feel as if, it's it's important that we take a holistic approach, a 30,000-foot view on this, and not make it a personal matter. This isn't about myself, uh, you know, as Carl. I do have to also represent the second senatorial, which is now not going to be represented in this lottery commission. I also take umbrage with the fact, if it is so true, as was testified by, Chairman, that the governor said that the island of Tinian and the leadership was not did not want us to appoint anybody. Again, I've spoken to the mayor, I've spoken to all the members of the leadership. No such communications have been conveyed to the executive branch or the governor, to that extent. So, I'm kind of concerned that there are kind of these fallacies going around, and also just by all of the things enumerated by legal counsel, it seems like this is just going to cause more problems than it aims to fix. And, yeah, I hope that the members and also the members of both houses take this into consideration as they deliberate over this. So with that, I yield, Madam Chair.
Thank you, Senator. Any other members would like to recognize Senator Donald?
Thank you, Chair. Just briefly, well, first of all, Council, thank you for all the new information that came about from your presentation this morning. I do want to point out that based off of our last meeting with the CCC and the request that was made, I did receive some recommendations by the chairman for amendments that could be made to the casino law, in addition to all the subsequent amendments that were made by law, and that was something I would have been, or I am confident enough to say that, regardless of the executive order, if any of the members, I myself included, would be interested in looking at these amendments and see how we can better we can improve the casino law to make it much more workable for any investor, for that matter, and that we take those into account in moving forward if the body decides to reject the executive order. But I think that with what the vice president had mentioned in regards to one investor that's currently on board, and whom is willing to take over the neglect of the previous license holder, I think this is something that is much more appropriate for the current commission to look further into. We've already spoken to the DPL secretary. I understand that in our last meeting, that was one of the issues that Team King was facing, is that there seems to be some sort of, I don't know if it's um, a problem they're facing with DPL, but from our conversation with the secretary, it seems like from what he understands, it's with the AG's office, if I'm not mistaken. But I think that in the event that the deal or any proposals with Team King doesn't come doesn't push forward, that's another matter that the body can consider in terms of uh, possibly what the governor is currently proposing, in the event that there's no other investors lined up to move. But then also, a lot of the recommendations that were made by the chairman and the CCC was to improve some of the requirements that in today's in our time now seems unrealistic, and it's not really enticing or inviting to the investors. And so I encourage the members, if you don't have a copy of that, the proposed amendments, that we'll share that with everyone. But I believe it was sent to all the members. And so with that, Chair, I think that I think this is something that we can close out in regards to reporting to the full body to take further action. Thank you.
Thank you, Chair. I recognize Senator Carl.
Thank you, Madam Chair. This is more just kind of rehashing and basically putting a timeline to some of the discussions that were made previously, and I want to thank the floor leader for bringing this up. When we spoke to the Casino Commission, they had made it clear that they hadn't been in contact with the Lottery Commission as it related to any transmittal of information protocols. The chairman talked about minimum internal control standards. I'm I'm very concerned that at this juncture where we're at, we're going to be giving so much responsibility to a group of individuals, as the council had alluded to, that have full-time jobs already. There are secretaries, they're not directors, they're not, like, you know what I mean, subordinates. They are the heads of their respective executive line item departments. And furthermore, there are no protocols in place that would facilitate the transfer of requisite information over to the Lottery Commission. There is no understanding on how long it would take for the Lottery Commission to take on this responsibility. What would they have to be aware of to be able to facilitate any future dialogue until such time that the governor so chooses to remove this executive order? And so there's just, again, there are just so many unknowns that I feel as if it would be irresponsible for us to be doing exactly what the executive order is asking us to do. And in the same vein that the floor leader just expressed, I think it's imperative that we bring this back to the legislature, sit down with all the stakeholders, and understand what we need to do to facilitate progress as it relates to gaming moving forward in the CNMI. So with that, I yield back. Thank you, Madam Chair.
Thank you, Vice Chair, Vice President. I do agree with your points, and also with our floor leader, Senator Calvo. Did you have anything to add?
Thank you, Chairwoman. I would like to just thank those that are presently here today that got the opportunity to come. Chairman Edward De Leon Guerrero from CCC, Mr. Demapan, thank you. Vice Chair, and Mr. Taitano, thank you. And we have, another representative, Brandon. Thank you for coming. And I just wanted to, in regards to this, the committee and everything, I just wanted to share that, the key constitutional statutory questions involved, and our legal counsel that got the opportunity to explain, does Public Law 1856 or subsequent laws legally permit shifting regulatory duties to the CLC without explicit legislative amendments to the Public Law 1924? That's one question in mind. And then, although we do have the executive order powers, is within the governor's authority, does the Constitution grant executive power override within the legislative statutory framework? Another question, I wanted to, just think about is, will, like our legal counsel mentioned, will this CLC be equipped to handle enhanced duties, ensure impartiality, and maintain public trust? is it lawful and unlawful with the evidence that we have provided in legal review. And then the case between Torres versus Commonwealth in 2009, and the other two executive order examples that justify, within CUC and the Department of Public Works, those cases under judiciary due process and, outcomes, it limits the government, the uh, authority to reallocate or reorganize without the legislative power. So, in that, that deliberation, I'm hoping we come up with the supportive, decision in regards to approve or disapprove this action. Thank you, Chair.
Thank you, Senator Ron. Recognize legal counsel.
Thank you, Chair. I forgot to mention, as you may know, the Senate and the House of Representatives have 60 days from the date of submission of the EO to modify or disapprove EO. However, the CNMI Supreme Court in Torres v. Commonwealth said or stated that failure of the legislature to modify or disapprove the executive order within 60 days after submission does not create a power in the executive branch to create new laws, which is a constitutional power granted to the legislature. The Torres court was citing another case called Sonoda versus Cabrera, 1997 MP5. The CNMI Supreme Court held in that case that the Constitution clearly vested the civil service exemption authority in the legislature, and the governor had usurped the legislature's authority by issuing an executive order modifying the list of exemptions. But the court also said the governor's actions were still constitutionally defective, even though the legislature did not reject the executive order after it was submitted. The Supreme Court found that silent acceptance was insufficient to create a power in the executive branch that the Constitution clearly reserved for the legislature. So the court, both in Sonoda and Torres, basically stated that even though the legislature if the legislature fails to disapprove within the 60 days, it still doesn't give the governor the authority to legislate by executive order. I just wanted to point that out.
Thank you, Counsel, and that's a very important point that you raised. Recognize Senator Ron.
Thank you, legal counsel, and thank you, Chair, again. And another point we wanted to bring out is the invite from our CLC. They are another key factor in regards to communicating and sharing and expressing their point of view. That's another key element, and other stakeholders in regards to the decision-making process. So that's very important that we understand their point of view as far as this whole thing and decision-making process is concerned. Thank you, Chair.
Thank you, Senator. So, if there are no other short recess, thank you. Brendan? So at this time, based on the information that we received from legal counsel, the review, the talking points that the members have made to include, the timeline that this would take if it goes into litigation, up to 3 years or more, and just really the overall concept of whether or not the governor usurped his authority. We want to make sure that there are separation of powers between the branches, and so that's what we are focused on to ensure that the governor did not overreach. So at this time, I would like to recognize Senator Caro for the proper motion.
Thank you, Madam Chair. And I would officially like to offer a motion for this committee to render a rejection on the Executive Order 2025-02 on behalf of the Senate Committee on Gaming, and that a committee report be produced for the full body of the Senate to adopt and dispose of in the upcoming Senate session. So move.
Thank you, Senator Caro. Can I get a second?
Second the motion.
Thank you. An offer has been made and seconded. L.A. Macaronis, please call the roll.
Senator Ronnie M. Calvo,
Yes.
Senator Carl R. King Neighbors,
Yes.
Senator Donald M. Manglona,
Yes.
Senator Karina L. Magofnia.
Yes.
Madam Chair, all members present voted yes.
Thank you, L.A. With 4 members voting yes, the motion passes. The motion carries. If there are no other discussions, we can move on to the next item on the agenda. Can I get a motion to adjourn today's committee meeting?
Motion to adjourn today's meeting subject to the call of the chair.
Thank you. A motion has been offered and seconded. All those in favor say aye. Those opposed say nay. Motion carries. Today's joint committee meeting is hereby adjourned at 11:02 a.m. Thank you, everyone.